better positioned to assess the seriousness of the claim and to prepare its defense. Another requirement was added is requirement to state the amount of any quantified claims and to the extent possible to estimate the monetary value of any other claim. That's Article 4.3d and Article 5.5b concerning the answer. And this will, among other things, allow the Secretariat to fix the amount of the advances and costs that are owed by the parties at an earlier stage on the basis of the amounts that are submitted by the parties themselves. And it will also enable the parties themselves to assess at the very beginning or have an estimate of what the arbitration will cost. Another requirement is the requirement to specify the arbitration agreement under which the claim is made. And that's in Article 4.3f, and for the answer it's Article 5.5d. And as you will see later, this requirement takes into consideration the issue of multiple contracts, and you will see later why this was important to be mentioned in both the request and the answer. Also, the new Articles 4 and 5 provide for this possibility to submit additional information or documents. And here again, these provisions are meant to encourage the parties to submit as many exhibits and documents with their first submissions, so they can really, brief their case already in their request and in their arbitration, not wait for the terms of reference to be signed. Just a very quick information or more information is about Article 4.1, which provide that the request for arbitration may be submitted to any ICC office. And that was added obviously because, as you all know, ICC has opened offices in Hong Kong, and the offices there could receive a request of arbitration the same way as Paris does. So there's a secretariat, a team basically, one of the 8 teams that Jose referred to earlier is based in Hong Kong.
Of course, in the course of the years, we may open other offices in other parts of the world with case management capability. So it was important to make that change and make it clear that in the future no longer only Paris will be receiving these requests for arbitration. I think, Lara, that's very, very useful because with the request and the answer, as you said, the parties are now able to set forth their case. Sometimes in a better way, in a more complete way, and it's also a very good. It's done in a very good way because it also leaves the flexibility for the parties to include as much information as they want. But also, these articles tell you that if you include more information, it may be better for your case. So it leaves the parties the choice whether you want to submit a succinct request, but with a little bit more of information that was required in the past, or whether you want to submit a full statement of claim, the idea of a full statement of claim right away, because if you have that right away, if your case is simple, it's not very complex, and you submit everything that you have right away, that will enable the arbitral tribunal to reach a decision and to issue an award in a more faster way than if it then has to request the parties to make submissions at a later stage and so on and so forth. Perhaps, Lara, with that very good, useful introduction to the beginning of the case, we can now move on to the articles related to the constitution of the arbitral tribunal, which are also a very, very, very important at the beginning of the case.
Sure. So now we're going to move to Article 11, and we will be dealing with Articles 11 to 15. And if you look in Article 11, you will see that this article is under the section, the Arbitral Tribunal. Article 11 contains the general provisions of this section that relates to the Arbitral Tribunal. And this article, Article 11, deals with the conflict of interest and duty of disclosure of the arbitrators. Under the 1998 rules, the old rules, the threshold standard for conflict of interests of arbitrators was only independence. So the 1998 rules refer to lack of independence of arbitrators. Throughout the process of revision of the rules, it was discussed whether the standard should be amended by adding the obligation of impartiality.
Perhaps because I think this is a very important clarification, the one you just made, and I don't want the audience to leave with a confused idea. As you well clarified, under the 1998 rules, the arbitrators had an obligation of conducting the case in an impartial manner. And now impartiality, the concept of impartiality has been included in Article 11, which relates basically to the disclosures that the arbitrator needs to make at the beginning of the case. Perhaps you want to explain this as to this standard of disclosure that Article 11.2 now includes with respect to impartiality.
Yeah, sure. Actually, as you all know, when an arbitrator is nominated, or he or she needs to sign a form, and the form now is a declaration of independence, impartiality, availability, and acceptance. Yeah, and basically, if I think Jose, what you're referring to is if there's an objection to confirmation at the beginning, right?
No, just when the arbitrator needs to file the statement.
Yeah.
Before it was just a statement, a statement of independence,
yeah, okay.
And now, as
Yeah,
you well said, is they have to disclose not only issues that may question their independence, but also that may perhaps question their impartiality.
Yeah, this is exactly what you're saying. It's Article 11.2,
Yeah.
which require from the arbitrator now not only to disclose any facts or circumstances that might be of such a nature as to call into question his or her independence in the eyes of the parties, which is the subjective standard for disclosure, and that existed under the 1998 rules. So now that was added, he or she needs to do the same as to any circumstances that could give rise to reasonable doubts as to the arbitrator's impartiality. So it's the objective standard that is now applicable. And as I said, it's a statement of acceptance, availability, impartiality, and independence. The issue of independence and impartiality, as I was going to say earlier, also arises when the court is examining whether to confirm an arbitrator. So, as I said, if there's an objection to the confirmation of an arbitrator who was nominated by a party, then the court is invited to decide whether to confirm or not that person, based on the rules now, so independence and impartiality. And the court's practice has usually been to apply a higher threshold when deciding to confirm an arbitrator at the beginning of the arbitration than when an arbitrator is challenged. So these are two different decisions that the court is taking. At the very beginning of the proceedings, if an arbitrator, as I said, is nominated and there's an objection to that to his or her nomination, the court would have to take a decision whether to confirm him and he could stay and be an arbitrator in the proceeding, or whether not. And again, during the proceedings, one party under the rules can request or challenge an arbitrator, and here again it's for the court to take a decision on whether to accept or refuse the challenge. And usually the court applies, as I said, higher threshold is stricter when it decides whether to confirm or not an arbitrator. And that's the reason being that the courts want to ensure that the tribunal being constituted has the total confidence of the parties at the very beginning. Everything starts on how can I say? There's no issue about the independence, and everyone is happy with the tribunal, and so everything is starting well. Whereas when there's an arbitrator that is challenged during the course of the proceedings, you can imagine that the court will have to think and take into account the stage, for example, at which the proceeding, or the stage that the proceeding, by providing for certain situation in which the court could make direct appointments. So if the court does not accept the proposal that was made by a national committee, or if the national committee does not make the proposal within the time limit that was fixed by the court to do so, the court may either repeat its requests, or it may request a proposal from another national committee, or it can make a direct appointment. So now the court has more latitude to appoint an arbitrator, especially when there are delays or inappropriate proposals that are made by the national committees. In addition, new Article 13.4 provides for 3 special situations in which the court may also directly appoint an arbitrator. So these situations did not exist under the 98 rules, because as I said, under the 98 rules, the court had only one possibility to appoint an arbitrator. It was to go through national committees. So now the 3 special situations is: 1, when a state or state entity is a party, the court can or may